This is the Lebenthal Report with Michael Hartzman and Dominick Tavella. We'll break down the news, trends, and overall direction of the markets, telling you what may be coming next, investment opportunities, and what to avoid. Now, here are your hosts, Dominick Tavella and Michael Hartzman.
All right, I'm Michael Hartzman. Today is Tuesday, April 19th, 2022, along with my partner, Dominick Tavella. How are you this evening, Dominick?
Good evening, Mike. Doing well. No complaints on this side of the pond. So doing well.
Good for you. Well, I appreciate you staying up late to do this. I know you're in Europe, so thank you very much for staying up past your bedtime on a Tuesday night.
No worries. No worries here.
We're good. Well, I guess you'll be happy to know it's still winter on April 19th on Long Island. It was freezing today, which is why I still have a pullover on. I don't know if we'll ever be pulling these things away. They're going to go from winter to summer this year.
Well, be grateful because I heard it was a nor'easter and it could have been a couple of feet of snow. So it was warm enough to give you rain, and be grateful for that.
That's true. I did talk to a buddy of mine who was upstate. He said he had 10 inches when he left this morning. So I will be grateful for small favors. And I guess the other small favor would be that it seems to be, Dom, that Tuesdays are the lucky day of the week, because I think this is the third or fourth Tuesday in a row that we've had, dreadful days one after the other, and then we do this show and the market's up. But the market's we had that March rally off of January, February bear market, basically, and it's been a bit of a slog for the last 2 weeks since April began.
Yeah, we did this show last week, and we were concerned, and we expressed our concerns. And overall, the S&P was down 2% last week. But we got off to a pretty good start today, and a lot of it having to do with companies finally starting to report their earnings. And it looks like at least the first wave of reports have been pretty positive, and maybe not quite the doom and gloom that some of the experts are talking about, hopefully.
Earnings are always important, and I'm not terribly surprised we've had good earnings, because at the end of the day, when you peel back the onion, we still have a decent economy right now. I guess the fear has been this overhang of inflation / rising interest rates / recession that the market still can't seem to get its brain around.
And it's evolving, right, Mike? So it's understandable. We've talked about this many times that, corporations have to try to absorb these higher costs, see if they can pass some of these higher costs on to consumers. Are consumers really willing to pay them? So there's a lot of unknowns right now, but companies are giving out their earnings for this quarter, earnings per share, and in some cases giving us some kind of guidance. And at least for today, the news was relatively positive. I don't think it'll be this good every day, but overall, I think we might get a week or two here reprieve with some positive news, hopefully, and maybe take some of the stress out of the market.
And as we talked about this morning with the call we have with our reps, maybe if the Standard & Poor's and the NASDAQ, this is kind of where they bottom out in the short term, which is about, half. We've given back about half the gains, or the other way to look at it is we haven't revisited half the lows. So if we could form a new bottom here, I think that also could be optimistic for the market rebuilding going forward.
And Mike, I couldn't agree with you more, but markets never go straight up, they never go straight down. It's two steps forwards, one back, or when the markets are going down, two down and one forward. So I think this is part of that process. I hope you're right that this is a bottoming process, creating a floor here where we can build off of. And maybe if we start to get positive or better economic news as we go through this year, maybe we will have seen the bottom. Hopefully we will have seen the bottom.
To be continued, right? We'll know in a couple of weeks. But on that note, Dominick, our guest tonight is an old friend of ours, Harold Bollaci, who's an attorney on Long Island. And the reason we asked him on the show is you and I had a conversation, and it dawned upon us, with many of our clients living in the state of New York, and with their portfolios have done really, really well, and with their homes really expanding in value kind of considerably over the last couple of years. We really thought it was important to have our clients revisit the New York State tax thresholds and how it possibly affects them. Because I think many people thought, oh, I don't have enough money to worry about estate taxes, but they might. And we wanted Harold to go over some of those points tonight.
Yeah, and Mike, even though we're going to focus on New York State, every state has their own set of estate taxes, or as I love to call them, death taxes. The federal limit is pretty high, but each individual state has their own rules. And you definitely need to look at it and be aware of it and see if any planning should be done. So I think this is a perfect topic to cover tonight.
I agree, and we're looking forward to have Harold and his points on, and we will be right back right after this break.
Lebenthal.com. Now, back to the Lebenthal Report.
All right, I'm Michael Hartzman, back with Dominick Tavella and our special guest this evening, Harold Bollaci, an attorney on Long Island, specializing in all matters related to someone's estate and trust affairs. How are you, Harold?
Very well. Thanks for having me.
Welcome, Harold.
Back.
You're welcome. So, Harold, when we invited you on the show this week, it was with the special intention of talking specifically about state estate taxes. I know it's a tongue twister because most people have their brain around the federal. That's what they focus on. It's a really high exemption. I think it's over $11 million now, or close to 12. And anything up to that number, you pay zero taxes on. But individual states, as Dominick pointed out, have their own unique set of rules. And New York in particular has a pretty harsh rule that, as Dominick and I, look at our client portfolios and their house, they may really want to have a better understanding on how that works, because they may have a state estate tax problem unknowingly. And that's what we wanted you to get into a little bit this evening.
I like how you say.
Yeah, I'm going to interrupt you because I just want to kind of focus this for our viewers and our listeners. So we pay income taxes on the monies that we earn every year, and then there might be capital gains taxes or other types of taxable on your income. But when you die, if you're over a certain limit, the federal government wants another chunk of your money. And in this case, the topic for tonight's discussion is the state that you live in may want a chunk of your money. Death taxes.
Death taxes. And we all live in a state where there is a significant death tax. And depending on where you are on the death tax scale, it can be quite punitive. And so one of the things we thought we would talk about is how to mitigate that and plan for it. So we're going to focus on New York. I think about 15 or 16 states have death taxes. And a lot of them have lower thresholds than the federal estate tax. So that's why it's important for estate planning attorneys like me, and also for financial advisors like yourselves, to make your clients aware of some of these tax rates. So, for example, gentlemen, in New York, an estate tax for an individual is an estate pass is tax-free up to $6.1 million for an individual. That's very important. But the minute you go over that $6.1 million mark, it can get quite expensive. So for example, at 6.1 million, your estate tax is zero. But if you go to 6.3 million, your estate tax is $424,800. That is an enormous gap. And as I said a minute ago, I feel like it's quite punitive, because a lot of people may not realize that they were that close to, we call it falling off the cliff. They were prepared. They knew they were wealthy. They had $5 or $6 million, but that extra $100,000 can cost your estate hundreds of thousands of dollars. And there are ways to plan for it. So let's talk about how to do that.
So Harold, before you do that, describe briefly what assets are counted towards the estate. Is it the IRA? Is it your house? Is it life insurance proceeds? Is it investments? Or is it all of the above?
Yes.
Yes.
Thank you for doing that for me.
You're welcome.
It's pretty broad. So you have your estate tax, and this really is something that needs to be worked on with, I think, financial advisors, accountants, and estate attorneys, because there's a certain range in the New York State estate tax where it can really punish the decedent's estate. And that range goes from 6.1 million to 6.7 million. And that's where you're looking at the overage of the exemption as it relates to the tax applied. So for example, when you get up to 6.7 million, the tax is $600,000, and that represents 100% of the overage from the exemption. So if you fall within that range, you should plan to reduce your taxable estate. And there are some really interesting ways to do this. Obviously, the first way to reduce the size of your estate is to give some money out. I'm always advising clients at this level to start making some gifts, utilizing the annual gift that's permitted under the federal estate tax law or the federal law, utilizing part of your unified credit over your lifetime. But sometimes
So Harold, I'm going to interrupt you for a second because I want to focus on the first thing you said. You're allowed to make annual gifts. What is that amount?
You're allowed to make, I think it's 16 or 17,000 per year per person right now.
So
it's a great way to reduce your estate. Yeah, say you have 10 grandkids, gifts, right? You can unload $160,000 to 10 grandkids, and it's perfectly permissible.
And you can do that annually.
Correct. Here's the challenge as it relates to the New York State estate tax. Any gifts or transfers that are made within 3 years of your date of death may be clawed back into your estate. So if you're going to do gifting to mitigate your New York State estate tax, that's a tongue twister, like you said, Michael, you need to be prepared that it may be clawed back. So this isn't something that you should wait to do. And that poses a challenge because people like to hold on to their money. One of the really nice ways, especially if you fall within this range where the tax hits the hardest, is to include provisions in your last will and testament or a revocable trust that says, if my estate tax is X, I hereby direct my executor to make a charitable gift to this organization. And that can bring your estate tax, that can bring your taxable estate back down below the exemption level and completely save the estate that $500,000. It's called a Santa Claus provision in the industry.
So you can make a gift after you're dead in order to avoid the and we'll call it the New York state tax, is what you're saying.
That's right.
Wow.
Yeah. And you can use language that says, if my estate is going to be subject to, so it's a conditional bequest.
Mm-hmm.
The bequest only takes place if your estate is going to meet that threshold. Because you may not want to make that gift. I mean, hopefully people are including charitable gifts in their estate plans. A lot of people don't, even the very wealthy, but this is a really great trigger clause that can be included in a will or a trust that can save, almost $600,000, depending on where you are on that scale.
So we have these annual gifts that you can pretty much give to anybody, correct? It doesn't have to be a grandchild or a
family member. That's
Be
right.
any family member. You have gifts you can give to charity. Then you talked about a unified gift. Did I get it correct? A larger gift that you can make, or a larger transfer that you can make over your lifetime.
Well, that's at the federal level, Dom. We're focusing here on New York State. The unified is the overall federal credit. So during my lifetime, I can give away my unified amount, which is different than my annual amount. So that presently is $12 million for an individual and twice that for a couple. At the state level, it's about half, but the clawback is what people need to worry about in New York. So if you start doing this a few years before you die, you may not accomplish what you're seeking to accomplish, which is keeping yourself below that $6.1 million level. So adding language like this into your estate plan, where you use a charitable bequest to reduce the size of your taxable estate, that's kind of it's a safeguard. It's a catch-all. But again, if people are giving out a lot of gifts, it's going to get clawed back into your taxable estate for New York estate tax purposes.
So Harold, we hear all the time, and Dominick and I use various tricks that we are aware of to avoid probate, right? We always tell our clients, you always tell our clients, you have to avoid probate. So hypothetically, if a client has a $7 million tax estate, right, and they pass away, but it's IRA money, it's insurance money, it's transfer on death accounts, meaning they all are designed to bypass probate. And now the executor or executrix does the estate tax, and their accountant or lawyer says, well, you owe $700,000. If all the money has been distributed to heirs vis-a-vis beneficiary and insurance claims, how does the tax get paid?
That's a great question.
Thank you.
I've never encountered it. I'd be asking you that question. I've never encountered that scenario, so I'm not going to speculate. I know that's not what you want to hear on a radio show, but I'm the first to admit when I don't know an answer to a question. That's a great question.
Well, Harold, these things are unscripted, so I wasn't trying to paint you into a corner. I apologize.
I can make it up, but I'm not. That's a terrific question. The state generally seems to get their money one way or the other, so consider that.
Gotcha.
Yeah, but I think what you should also think about here is, unlike the federal estate tax, the New York State estate tax is not portable. So if you have a married couple and say they're worth 10 million,
Mm-hmm.
and the husband dies and all the assets are titled jointly, everything passes to the surviving spouse.
Mm-hmm.
That surviving spouse is going to have a very significant New York State estate tax. So couples need to work on doing joint mitigation by separating their assets out of jointly held accounts. So what you would do, for example, if you had a couple worth, I like to use the $10 million mark because I think that's a good number that everyone can compute. You'd separate it out so that the first to die, that spouse's money remains in a trust for the surviving spouse to access, but it does not become part of the surviving spouse's taxable estate. That is a really important device that wealthy couples should be using, especially at that level, because that could cause a very significant tax for the surviving spouse. So the idea is just separate jointly held assets into two separate revocable living trusts, one for the husband, one for the wife. And when the first spouse passes, there's a provision in that person's trust that the surviving spouse may disclaim his or her inheritance, but will be available to access the income and a certain portion of the principal from that trust, but it doesn't become part of the surviving spouse's taxable estate. That's a really important planning tool that attorneys and accountants and financial services people should be using.
So Harold, what do people do when, and this obviously could be a very large liability, how quickly is it due? And what do people do when they have assets like buildings or apartment buildings or large pieces of commercial estate, real estate where it's not liquid? What do they do?
So that's the biggest challenge, especially for us as New Yorkers, and anyone who's investing in real estate. When we were in commercial, we were talking about the markets. Now today may not be a good day, even though the markets were up today, to start liquidating assets to pay taxes. And this has been an issue for individuals for a very long time now, that you amass all these illiquid assets and you pass away as a fairly wealthy individual. And now your heirs are forced to liquidate assets to pay estate taxes. And as a result of that, the heirs may have to pay capital gains taxes. So it causes a multiple taxation event. So good planning focuses on mitigating that taxable event. And there are several ways to do that. Some people buy insurance, life insurance, to mitigate estate taxes. And that's a calculation. Are what you're paying for the premiums less than what the actual tax would be? So if you anticipated $1 million tax bill, how much are you going to pay to insure against that tax bill? Another strategy that I like to use, and it's all timing, is identifying assets that you think may appreciate rather dramatically over time. And what I recommend to clients is transferring those assets into an irrevocable trust. So you gift them at a lower value into your irrevocable trust, and the irrevocable trust captures all those gains during your lifetime, and it passes outside of your taxable estate. Those are two really good strategies for tax mitigation, but it requires a fair amount of planning and a fair amount of analysis, because nobody thinks you're going to pass away tomorrow. So you're trying to do this planning based on current laws. And as you know, the exemption rates, thankfully, have gone up over time, but you need to really monitor what the New York state and federal limits are. And there's always conversation about rolling back New York or federal estate tax rates.
Harold, I have numerous more questions, as Dom does, but we are bumping against the break. So let's take a quick break, and hopefully you could stick around, because we have a few more questions for you.
Got it.
We'll be right back right after this break.
Now, back to the Lebenthal Report.
All right, I'm Michael Hartzman, back with Dominick Tavella and our special guest this evening, estate attorney Harold Bollaci from the great county of Nassau on Long Island.
It really is a great county.
It is a great county. Harold, I'm going to throw two expressions at you and then a number, because we always assume that whatever happens on the federal level also applies to the state level. So when you mention an irrevocable trust, is it safe to assume that the five-year window is still in effect, that money basically has to be out of someone's estate for 5 years in order for it to be completely out of their estate? And then the other question is, in New York State, do we still get the spousal exclusion, where a surviving spouse does not have to worry about any of this at the moment, and spousal waiver?
Two very good questions. I'm going to take the second part first. I feel like I'm on a game show. So the surviving spouse does not take the deceased spouse. It's not portable. That's
Okay.
why I was talking about separating it out for wealthy couples. If one spouse doesn't use their exemption, if you will, it's not portable to the surviving spouse, which is why it's so important to separate the estates if you think you're going to have a New York
But
State.
Harold,
death
just to
tax
be
event.
clear, right? Just to be clear, on that first death, the surviving spouse does not have a tax liability. Right?
It
The
really,
surviving spouse would be able to inherit. It's on that
you're right.
second.
I'm sorry. I don't know why I paused. The answer to that question is yes, but the surviving
on the
spouse now
second
needs to be
death
concerned.
now.
You're right. I'm sorry that threw me
No,
for
it's
a
quite,
loop.
it's quite all right, but this is a very confusing subject, and we're trying to make it as
The
clear
answer to
as
your
we can.
question is correct. It's when the surviving spouse passes that the death tax really hits.
And
which
you
is
haven't taken advantage of the exclusion that you're talking about. It's use it or lose it.
that's right. You have to use 100%. Use it or lose it.
That's why the planning is so important in this process.
Right, because at the federal level, the federal exemption is portable. So that's what's so confusing. The surviving spouse can take part of the first spouse's exemption, but at the New York State level, it's not portable. So you use it or lose it. Yeah.
Harold, one more question for me. Many of our clients have children and grandchildren with special needs.
Yeah.
And you've written many trusts for our clients where the special needs trust goes into effect upon a person's demise, correct?
Right.
So my question is, which comes first, the chicken or the egg? If you have created a special needs trust upon your demise, but then you discover or the children discover that mom has a $7 million estate, does the special needs trust get funded before the estate tax get paid or after the estate tax gets paid?
So if you're funding it as part of your estate, the estate tax gets paid first.
So New York
Yeah.
State will step in front of a person with special needs.
They will step in front of them, run them over, you name it.
I would argue any beneficiary, right,
Right.
Harold? They
Remember,
wanted
the government
taxes
always
first.
comes first. In fact, the first two paragraphs of most wills say, I hereby direct my executor to pay all my debts and any state and federal estate taxes. That is the first thing most wills say. So it's nice of you to think that the government cares about special needs. They don't. Money is money. So for individuals planning for special needs, they should try to fund those trusts if they can during their lifetime by using some of the gifting strategies that we were talking about at the beginning of the program. It's an evolving process. I talk to people all the time. I had clients in this morning. I said, look, we're going to work together for probably the next 15 years because what you're doing now is great, but so much is going to take place in the next 10 to 15 years that this is going to evolve. The challenge is people don't want to do this because they're fearful of their mortality. People don't want to relinquish control over their assets, but good planning over time is how you really maximize the value of your estate. And it just seems foolish to permit the state to take all of this money where you had the opportunity to really save so much on behalf of your estate during your lifetime.
And Harold, I certainly don't want to disagree with anything you're saying or argue that you shouldn't be doing long-term planning, but the rules change, right? We sit here, we create these master plans for clients and the grandiose design, and you create these documents, and then they change the rules of the game.
It's a constant challenge. And the three of us, along with millions of other Americans, spend countless hours trying to contemplate how those rules are going to change in the future. You need to do good planning based on the idea that you might not be here tomorrow. And it's worst case scenario planning, but it should be well thought out. And like you do, I tell people this is something that you need to revisit every time the laws change and every time something important happens in your family life or your financial life. Yeah, it's hard to plan, but
And Harold, I guess you kind of let the cat out of the bag. My thought process here is that clients have probably spent an exceedingly large amount of money years and years ago to create these documents with a plan, and then maybe they have not been revisited in 10 or 20 years, thinking it was done, and maybe you need to have it looked over again.
always. And I mean, just think about how dramatically the estate tax laws, both at the New York State level and at the federal level, have changed in the past 2 decades. I'm practicing law now 21 years. When I started practicing, the limits were in the $600,000 range. I think it was $675,000 was the exemption. That seems like pennies compared to today. And 20 years isn't a long time, but the rules have changed dramatically for the better, I would add.
Harold, I know this is a subjective answer you're going to give me. What is the optimal age to fund an irrevocable trust?
So like a good lawyer, I'm going to hedge a little bit and I'm going to answer the question 2 ways. It depends what your goals are. If you're using an irrevocable trust for estate tax planning, that's a numbers calculation. You really need to look at what you're worth today, what you think you're going to be worth in the future, and what you think the tax is going to be. So that's very, very focused on your current net worth. For most people who are not doing irrevocable trust for tax planning, but are doing it for Medicaid protection or asset protection purposes, it can be much later in life. I think 60 is probably too early. Most of the time, I think 70 is the right time to start thinking about irrevocable trust planning. Unless you have a pre-existing condition, unless there's something in your family where you think that at a younger age you might develop a cognitive disorder. But I think 70 is a fair age because remember, you're trying to capture that 5-year Medicaid look back. So is it unreasonable to think that you might need some type of care at age 75? Probably not. I've gotten to a point where I think 80 is still fairly young because I have so many clients who are vibrant and healthy at 80, but I still think that waiting till age 80 to try to do planning to achieve a 5-year look back might be a little bit too late. So for Medicaid purposes, I would certainly say that the optimal age is 70 years old. Absent evidence to the contrary. Yeah.
And Harold, maybe I want to take a stroll back. Mike brought this up really when we first started this conversation. You talk to a client, and it happens to me all the time where, I kind of tongue in cheek go, do you guys think of yourselves as millionaires? And they smirk and they go, oh no, not us. We're not millionaires, but you look at the price appreciation in homes over the last decade, as well as the stock market's done over the last decade, value of retirement plans, stock options, that things that people accumulate their life. They don't really assign some kind of intrinsic value to them, but you start adding all these assets up, and it sounds like 6 million seems like an incredibly large number, but it's almost shocking how many people really do meet that threshold. I've seen, Mike, I'm sure you jump in on the same comment. We've seen clients that, seem like everyday middle-class people, and they are, except that when they pass away, all of a sudden the investment they made in a piece of real estate, or again, a home or a second home or retirement plan, it's not that hard to get to $6 million.
It's not. And that's why it's so important for us as professionals to have the detailed conversations. And it happens to me a lot. People say, oh, you wanted to know about that too? Or, oh, that's part of my taxable estate. And to your point, people are living a lot longer. And if you had good savers as clients, just compounding over time, it's not unusual for millions of dollars to accumulate. One of my greatest pleasures in the practice of law is saying to people, you're a multimillionaire, right? And, oh, no, I'm not. There's no way. And you do the math. Your house is worth $1 million. You got 2 million there. You got $1 million there. You got $4 million. These people haven't purchased a new car in their whole lives. They don't even like to go out to dinner. But
well, that's why they're millionaires. But
that's why they're millionaires. Exactly. But just over time, good savers, well-managed portfolios, it's very easy to accumulate millions of dollars and either not realize it or not appreciate what you've accumulated, because it may not all be in one basket where you see, oh, wow, I've got $5 million in one place. It might be in several different places. So you never really see that number with all the zeros on it to make you feel like you've saved that much or generated that much wealth over your lifetime. But certainly for people compounding, you get to age 90, if you've been saving for 70 years, we've all seen it. It's a wonderful thing.
And guys, don't forget the life insurance, because the life insurance is income tax free, but those life insurance proceeds, correct me if I'm wrong, Harold, get counted towards the estate threshold.
100%. You see me nodding vigorously. You're absolutely right. And people forget that a lot because they don't focus on the insurance policies. They may have been paid for 20 years ago, and they're just there, waiting for you to pass away. It's a great point, Michael.
Yeah, because the financial advisor will say, oh yeah, don't worry about it. It's income tax free to your heirs. But again, with all these other values of property and assets increasing, not that the insurance is a problem, but the insurance kind of could sneak up on the survivors.
How it's owned could be a problem.
Yeah.
Absolutely. Yeah. 100%.
Especially on Long Island.
I'm sure there are people listening to the show going, well, that's not me. It's not a topic that's pertinent to me. But, we've talked about quite a few times this evening about longevity. So you look at a 60-year-old that might have just maybe $1 or $2 or $3 million, but if they live to 80 or 90, now that $2-3 million could turn into 6, 8, 10 million. That's the power of compounding that you just mentioned, Harold. And it really does work. So don't just think about today and what your net worth is. Think about what it might be 10 years from now, 20 years from now, 30 years from now.
Well, and I think it's really applicable, Dom, because, we're blessed with a lot of clients who have really nice income in retirement. So they're not drawing down on their savings. They saved for a reason, but they're blessed with a nice pension, high Social Security, even RMDs. Their portfolios are growing faster than their RMDs are distributing the money. So yeah, you go from 60 to 90 and your net worth tripled.
Dom, I know for a fact that our firm, between you and I, we have well over 200 households that have well over $1 million with us, well over $1 million. And again, if they live on Long Island or in New Jersey, their home could be worth $1 million, $1.5 million. So I know that book was written many years ago, The Millionaire Next Door. I mean, we represent the millionaire next door, Harold.
Absolutely. The three of us collectively, and most of the people next door are probably millionaires. It might not be liquid, but
Harold, that a lot of these people, again, our clients included, go, well, that's not really me, right? I'm really not. Literally, they sit there and shake their heads. I don't care what that piece of paper says. I'm not a millionaire, right? And we've all had that experience. But maybe they're even listening to the show today, and they're like, well, that's not really an issue for today. But I think that's exactly the point, that it may not be an issue for today, but if you live long enough, it'll definitely be an issue for tomorrow and for your heirs. Maybe a little smart planning today prevents a big, big headache tomorrow.
It's certainly something that should be on everybody's radar. and they should be taking steps to mitigate that possible damage. You know, it breaks my heart when I see clients who are settling estates and writing enormous checks to the state of New York.
Harold, I got to ask one question before we run out of time. So can you move? Do you leave a state that has this egregious
Sure.
tax? Can you get
Sure.
away from it?
Sure. Retire to Florida, 100%. But, you know, this applies to people who are non-residents as well. If you're a non-New York State resident with property in New York, you're going to have to file a New York State estate tax return. So be mindful of that. If your investments are in real estate or something else in New York, and you live out of state in a non-death tax state, you're still going to owe New York State estate taxes. So it's very important that people be aware of that. Just because you don't live here, you may still owe taxes here.
Interesting.
Yeah.
Harold, thank you for your time this evening. The time went flying by. This was a lot of great information. And if any clients have any particular questions for you, we certainly know how to find you, and we will point them in your direction.
I appreciate that. Thanks for having me on. This was really interesting.
Thank you, Harold. Appreciate you joining us.
Thank you.
We will be right back right after this break.
Now, back to the Lebenthal Report.
All right, I'm Michael Hartzman, back for a quick wrap up with Dominick Tavella. You know, Dom, I'm glad we covered this topic. This was interesting stuff this evening.
It's interesting. Again, what my concern is that some people out there, we throw a lot of numbers around, Mike, and a lot of people might go, well, that's just not me, right? I don't need to worry about it. I don't need to think about it. And my answer is going to be just ask your financial advisor, right? Have an honest conversation with your wealth advisor or with your estate planning attorney. Hey, should I be thinking about this stuff, right? And I think most professionals will give you good advice on how to at least start planning about it.
Yeah, I mean, look, as we said all night, between your life insurance, your home, and your assets with us, you could easily get precariously close to $6.1 million. You just can.
And stressing that even if you're half that number today, right? Over a 10-year period that could double, over another 10 period that could double again. So even the millionaire today 1 million today is 2 million in 10 years is 4 million in 20 years. So this doubling actually does happen, right? So a little planning today could save a lot of money tomorrow.
And even if you do the planning and you wind up shifting assets around, normally, even if the government lowers the threshold, and they normally don't start all over, even if they lower the threshold, as Harold said, they're not going back to 600,000. So any planning you do, it would be unlikely that it got completely outdated, or you would have to completely do your plan all over again. But you do have to stay on top of it, as you said earlier.
Yeah, I'm glad you mentioned that again, Mike, because we see it pretty regularly. New clients come in and we ask them for their documents. Bring them in with you. Let's take a look at them. We have people like Harold that can review them for us, right? And sometimes things become outdated. And sometimes it could be your beneficiaries are different, or your executor is different, or changed, or maybe deceased, right? So you should have your documents reviewed on a somewhat regular basis.
And I guess the other takeaway, Dominick, is God forbid, when you lose a parent or a loved one, don't try to, if you're the executor or executrix, don't try to get it under control in a vacuum. Contact the lawyer who did mom's will, or your lawyer. Contact the financial advisors that you work with or that your parents work with, and just make sure when you start moving assets, you're moving them correctly, and you're moving them in a way that's advantageous for you and the other survivors.
Yeah, Mike, I mean, that easily is a whole nother show. Moving assets incorrectly, besides this death tax issue that we just spoke about, could result in huge income tax implications to the beneficiaries. So getting professional advice does not hurt. It's money well spent.
Yeah, no, and look, and I don't think anyone anyone could really settle a sizable estate by themselves anyway. They're going to need to get an attorney and an accountant more than likely involved in that whole process. And it's time consuming. I had a client call me the other day. She's the executrix for her aunt. She passed away. The woman in Queens passed away in August. And the executrix, Dominic, still does not have the letters testamentary to unfreeze the assets. We're going on a year.
Well, look, we know 2020 and into 2021, COVID played havoc with this particular issue where municipalities couldn't even get death certificates out.
Mm-hmm.
And think about what that did for states and paying taxes on a timely basis and getting assets transitioned to beneficiaries. It's been a nightmare.
It has. So look, I'm glad we covered this show. I'm glad you stayed up late to do it with me. I appreciate it. Next week, we're going to take off, Dominic, because we're both traveling. And we will be back with the Lebenthal Report on Tuesday, May 3rd.
Looking forward to it, Mike. Have safe trips, safe travels. I'll see you in a couple of weeks.
You got it, buddy. Have a good night, everybody.